Hey guys, welcome to today's webinar. It's great to have you here this afternoon. I'm delighted to have Angus Burns. He's the partner in financial services advisory at Grant Thornton, who are a long-time partner with us. In fairness, a great sounding board for the association over the years. So different the SCARP initiative firstly, and then Angus, you can share your screen there when you
Thanks
get
very
a
much.
Second.
You're coming in and out there, Keelan, just on the sound, yeah.
Okay.
So, but you seem to be okay now. Whatever
Okay.
whatever
Great.
you've done there.
Sorry, it's only an intro anyway. I can hear you perfectly now.
One. What I want to do is show these slides. Can you see those okay?
Nope, not yet now. One sec. No, hit if you hit share.
Yep.
And then click into your PowerPoint.
Oh yeah.
There we go.
Lovely.
Lovely. Full screen. And then just hit the
swap it around. Yeah.
Perfect.
Lovely.
Perfect.
Okay. Okay, thanks very much, Keelan. I think you gave an introduction there in terms of myself. I'm a partner in restructuring Grant Thornton. I've been at the insolvency game for 20 years now, always with Grant Thornton, and we've seen a couple of recessions in the meantime. But look, there was always certainly always a flow of restructuring whenever. For various different reasons. You know, it's the nature of business that you know, things change, decisions are made. Sometimes they don't work out, and always a requirement for restructuring. It's really part of the business environment. However, last April of last year, certainly something very significant happened in the form of COVID. The response from government, we didn't foresee. An amazing different way of looking at things and approaching the market. So you know, while we had quite a busy first half of last year, from the summer on, interestingly, the market restructuring was relatively quiet, and we think that is down to the very significant supports that came in from central government, as well as creditor pressure not necessarily being in the market, and that's borne out by the insolvency stats that we have seen. Notwithstanding that, we know that there are problems out there. There has to be problems. One can only walk up some of the main thoroughfares and see the level of impact that we've been experiencing, that we know about. So what I wanted to talk about today is, and you'll forgive that we'll go into some quite technical pieces around insolvency and restructuring, but obviously we need to know what's in the toolbox, what's available in statute, in law, what we can rely on where there's a difficulty with creditors and where there's a restructuring required, in particular formal restructuring. That doesn't necessarily mean that all cases requiring restructuring would use a formal restructuring scheme, but it is the potential fallback where informal negotiations don't succeed. And I suppose in many instances it forms a base for discussions. And sure, look, we can agree something that's better than the base position. So this presentation today is very much about going through what is available to businesses that do require restructuring. And in that respect, what I'm going to lead on is liquidation, which tends to be the default position in terms of what the waterfall looks like for creditors on liquidation. in particular the company-led route, can involve a continuation of the business post-liquidation, i.e. a transfer of business out of liquidation. We'll look at some of that. We'll also look at other company-led initiatives like examinership and schemes of arrangement that involve the preservation of the existing structure, but some fairly severe surgery to balance sheet and ongoing contracts, including leases. Maybe we'll touch just on creditor-led liquidation, what that might look like, and very briefly on receivership. Certainly, we had a huge number of receiverships starting 10 years ago or 12 years ago. I'm not sure whether we're going to see the likes of that again. I think there's a very different climate within the banks and politically, but it's certainly still a feature. Banks have to protect their security, have to protect their lending, and will appoint receivers going forward. I wanted to touch on the non-corporate solutions around personal insolvency. The new legislation that came in 2014 being very much around consumer debt and mortgages in particular, but of course it's designed also for sole traders, for those who haven't incorporated, and there are schemes to deal with debt in that instance while avoiding bankruptcy. More recently, last month, we had the rescue process draft bill was introduced. Hopefully it'll come into law in September, provide another tool in the toolbox. I'll touch on that towards the end of the presentation. Look, it wouldn't be a webinar without the V-shapes or the various shapes of recovery. And I suppose retail and hospitality are the primary affected sectors that we're seeing. Look, I suppose all these shapes have a general theme where there is a full recovery in the future. What we don't have here is a K-shaped recovery where you might have a certain part of the business escalating northwards, doing really well, but you have another part of the business where it's just not going to come back to where it was before. And I think that really is a feature of the sector that we're looking at and that we're involved in, because there's been such fundamental changes to it. So, you know, do we have the appetite to adjust to those changes, to go with them? It's not just about dealing with the legacy matter, you know, it's also about reshaping for the future, whether we have a business or where the business is at. I talked about using the base case scenario to negotiate informal settlements, which really has to be the ideal. I suppose the problem with informal settlements is that they're possibly best suited to a smaller number of creditors, much harder to put together an informal settlement that is, I suppose, non-legally binding, or you cannot force creditors into an informal settlement. You can in formal settlements that we'll look at today, liquidation, examinership, etc. But informal settlements is by consent, much harder to bring multiple creditors into the tent, and harder for them to all agree. The other theme to look at is, you know, if we are at the bottom of the cycle here, and if the balance sheet and reserves is exhausted, we've nothing further to put in, the balance sheet is at its weakest point, do we put in new investment now to plug gaps in order to drive on out the other end, while carrying the legacy position, legacy debts, and legacy contracts that have to be honored going forward? Or do we do some kind of a settlement situation, either informal or formal, and then put the investment in after, and use the investment into the company or the vehicle after the settlement as an inducement for, or an encouragement for creditors to agree to the settlement, and then power working capital going forward? So, you know, there's a decision to be made as to when that money goes in, and why. Really, the future viability of a business, you know, in some cases there may not be a business there may be a fundamental change to that piece of the market. But if there is viability there, if there is something worth protecting, or if there is something worth going for in the future, and there is a problem with the balance sheet, then there has to be some kind of a negotiation. There has to become some kind of a settlement to allow that business to flourish and employ people, etc., going forward. So look straight into generally the default scenario on negotiations for a corporate is that if there's no agreement amongst the creditors, then we're facing liquidation. Okay, so what does liquidation look like? Well, it's an inability to pay debts as they fall due. That's what insolvency is. One might also say that there's a balance sheet test to say that your liabilities are bigger than your assets, but I prefer the description unable to pay debts as they fall due, or indeed it might be that creditors are not calling in their debts. They may be owed significant monies, but they're not demanding debts and they're happy to wait. In that instance, while the balance sheet might look very, very weak with an excess of liabilities over assets, the company's not insolvent because it doesn't have to pay debts at that time. And I think that's been a feature of the last year, where in many cases creditors have not pushed hard for payment, but yet directors could certainly turn around and say, well, we will never be able to meet these debts. And that's a fairly subjective kind of an opinion, if that's what the directors want to be able to say, and they may well be able to say the company is insolvent and therefore we need to deal with the issue now. The company directors may have an eye on the future as well in terms of future business. The creditors voluntary liquidation is the most common of the liquidations. It doesn't involve any court process, so it's an out of court process in terms of appointing the liquidator. The only court process might be any kind of restriction, which is generally rare, of directors in the future might involve the court, but generally there's no court involvement in the process, so the costs are kept much lower. Once the directors form that opinion that the company is insolvent, they're obliged then to call a creditors meeting to appoint a liquidator. That's done with 10 days notice. A shareholder resolution is generally passed that morning, and the creditors meeting maybe half an hour later would be held, where creditors are invited to look at a statement of affairs and ask questions about the insolvency of the company, etc. It's passed by a 51% resolution. So that's important when you have two shareholders there. Perhaps they're 50-50, perhaps they don't agree to appoint a liquidator. In that instance, you're fairly scuppered in terms of using a creditors voluntary liquidation, because you need 51% of shareholders to pass the ordinary resolution. There are other options if you're in that situation. Some advantages are the control process. I always like to say it's better to be driving the bus than to have your creditors drive the bus. So it's better to be in control of the process, and company directors have control over who they nominate to be liquidator. Of course, that's subject to ratification by creditors, and creditors can nominate an alternative. In particular, I'd say in the current situation where we're at, where we have some very significant creditors remaining, such as the bank, landlord, revenue, employees, it might be that there's a smaller number of creditors, large creditors, who might be able to influence the appointment of a liquidator. In that respect, I'm particularly thinking revenue. Revenue have a panel of liquidators and might prefer to have their own liquidator come on as a liquidator of the subject company. So I suppose if the company directors choose a liquidator who's on the revenue panel, there are some certain nuances in terms of whether the directors appoint a liquidator or whether the creditor appoints the liquidator, in terms of how the liquidation might proceed. The liquidator's job is to deal with all the company's assets and the company creditors. The state has an indemnity called the Insolvency Fund, and Redundancy Fund, which will pick up employee entitlements, be them arrears of wages, arrears of holiday pay, compensation in lieu of statutory minimum notice, and indeed redundancy. So really redundancy is the big number there, because what we've had is a situation where the temporary layoff period of 4 to 6 weeks has been extended indefinitely to about 18 months at this stage. It'll be extended to the end of September, which, we're not hearing too much about it, but from a constitutional legal position, is very hard on employees not being able to move on. They have their redundancy entitlements. At the same time, they're really waiting on a liquidation to get those amounts paid. Conscious also the amount of casual labor in the retail and hospitality market might not be as big an issue. So it really might be revenue as the significant creditor with warehouse debts, landlord or bank. What we've seen already last year is this bed and breakfast type scenario where an entrepreneur might liquidate a company and then do a deal with the liquidator and the landlord to take on the lease in a new entity, buy back the fixtures and fittings and stock and get going again. So liquidation doesn't necessarily mean the end, it means the end of the company, but not necessarily the end of the business. Disadvantages are there is a report to the Director of Corporate Enforcement on the behaviour of the directors, whether they acted honestly and responsibly in the affairs of the company. A small minority, less than 10% of directors generally face restriction, and the bar is relatively high for that. In terms of did the directors put their own personal affairs ahead of those of the company. So really there's quite a high bar there in terms of did they act honestly and responsibly in the business. So we don't see too many restrictions as a result of liquidation. Unsecured creditors generally face a wipeout position because they rank after the preferential creditors, who are revenue, rates and employees, all of which could be quite significant. And of course, there's the reputational impact of having a liquidator appointed, and I suppose having maybe that black mark against you. Although in light of COVID, I think it's quite understandable how liquidations will happen. The other form of liquidation is the High Court liquidation. And this is generally a creditor makes a petition to the High Court to place an insolvent company into liquidation. But it also could be a situation where a friendly creditor of the company, or indeed the company itself, might apply to the court to appoint a liquidator, because it avoids the 10-day notice period in court. You might have you might not have that necessary 51% shareholder resolution to appoint the liquidator. But once the liquidator is appointed, more or less straight away, the liquidation follows in the same manner as a creditor's voluntary liquidation. So it becomes an out of court process. And there's quite a there's a larger amount increased in terms of what a creditor can petition for the wind up of the company. But the process for a creditor is quite long. Is quite, I suppose, difficult, can I say, and costly. So we don't see too many petitions, but the threat is always there of a creditor to potentially petition the wind up of a company. I would say it's a lose-lose scenario if the liquidation does happen, because the creditor doesn't get paid, has all the costs of making the petition, and obviously, once it's in liquidation, a liquidator is appointed. There's a minimal hope then for the business continuing in the future, and certainly no dividend to that unsecured creditor. Advantages again, the petitioner, if it's either the creditor or the shareholder, may be able to nominate their own liquidator. The notice period is not required. Shareholder majority, again, not required. Interestingly, I talked about a bed and breakfast scenario in liquidation, might involve the employee starting again in the new company. There is a risk there that the service and the years of service of the employees would actually transfer onto the new company in a creditor's voluntary liquidation. That is not the case in a court liquidation. There is no TUPE, no transfer of undertakings of employee service. And so a significant break there on the new company not having to honour redundancy or other employee entitlements. That's picked up by the state in the liquidation of the company. There is something called a provisional liquidation, where an ex parte application is made to court. The company or creditor appoints a provisional liquidator on day one, and then the judge sets a hearing date for the appointment of the official liquidator, perhaps 10 days later. Now, many contracts for supply or customer contracts might have a liquidation clause in them. However, the effective date of that liquidation clause crystallizing is the appointment of the official liquidator. So there might be a kind of a hiatus period of a week or 10 days where it's possible for a provisional liquidator to do a quick sale of a business as a going concern, preserving contracts. So for instance, if there's an important supply contract that is quite valuable, it might be possible to sell that retail business going forward without triggering liquidation clauses. And it, you know, brings the question of, do we have a purchaser lined up for the business? Can we do a quick deal to move the business out of the company in liquidation into a new entity without all the obligations and creditor liabilities in it, and move on into the future? So again, when we're talking to our stakeholders, our creditors, about doing a deal, the default position we're talking about here is a liquidation. And where do those creditors' claims sit in a liquidation? The first thing we do generally is draw up a statement of affairs in the liquidation format. Okay, now you do it both for statutory reasons because it's required in the creditors' meetings, but you also just do it for management information because it details the company's assets and liabilities on both a going concern basis and a winding up basis. And I'm always quite shocked to see the difference between, for instance, debtors and stock on a going concern basis versus realization of debtors and stock on a winding up basis. There can be a huge reduction in value on a liquidation basis. So that's always quite useful to show to creditors, and in terms of saying this is the doomsday scenario if a deal cannot be done. And as I mentioned, the statement of affairs is accompanied with a list of companies' creditors at the creditors' meeting. There's a different format in Examinership, but again, it's to the same theme: court liquidation also, of realizable value of assets versus a significantly larger number of creditors in a waterfall format. So what is that waterfall? Okay, so who comes first in a liquidation? Well, first of all is mortgaged property. The bank with a mortgage over generally property, or to the same kind of theme, it might be book debts, might be pledged as part of invoice discounting. And there might be some kind of form of asset finance that has the same effect as a secured creditor. After that come the costs of the liquidator, legal fees, the costs of doing the job of winding up. Then we have the super preferential creditor, which is generally quite small. It's the employee's share of PRSI ranks ahead of then preferential creditors, which is revenue for the 12-month period, and it can be any 12-month period, rates, and employees. The employee's position is often taken the place of by the Department of Social Protection, who have their insolvency and redundancy funds. And interestingly, revenues 12-month period may be an interesting one when you see the warehouse position. So you know, are there debts within the last 12 months for revenue or not, and do they get that preferential status that allows their liability to rank ahead of other creditors, such as other secured creditors? That might be a debenture that the bank might have a floating charge over non-fixed charge securities. So that might be just the likes of stock or the cash at bank, or debtors that aren't subject to invoice discounting. And then after that, you have unsecured creditors, and really they are at the bottom of the pile, unless they can prefer themselves in such other way that I'll look at. This is the format for the liquidation statement of affairs. You'd have one column, you'd have a going concern figures, which are generally bigger asset values. Then you'd have smaller wind up basis asset figures. You'd have a total there. First dibs might go to super preferential creditors, then any leftover would go to preferential creditors in a percentage of each. They might get maybe 10 cents in the euro or something like that. The bank on the debenture might get would get nothing in that instance, because any surplus would go to preferential creditors. And even below that is unsecured creditors. That could be the landlord, that could be suppliers who don't have any stock, retention title over stock, and they would get nothing in a liquidation. So that can be quite interesting to show to creditors that, look, really the outcome on liquidation is not good. We need to discuss another way to do to fix the problem. There are, of course, ways that creditors can skip the queue. You know, suppliers of stock may have retention of title over stock, and they want to get paid for that stock. If they don't, the ownership of that stock remains with them. There's set off there by creditors and debtors, contrapositions. You even see banks maybe setting off accounts against amounts that they're owed, so they might be using the cash at bank to set off immediately against what they're owed. That goes contrary. This all goes contrary to the priority of creditors' claims. But you can see creditors trying to prefer themselves in a winding up. Transport companies might put a lien over stock. If judgment is got by the landlord, there might be a judgment mortgage on property, attaching to property, which again in the company, which might rank ahead of all other creditors, and might appoint the sheriff to execute against goods in the store. So these are all ways of creditors to try to prefer their position. And if things get quite bad, then it might lead to this. So it's all the more reason to maybe avoid getting this far down the road, and to engage a bit earlier in trying to sort out any restructuring that's required. Ditto certification and warranty. There might be goods that are supplied that require ongoing warranty, and the supplier of those goods might insist on getting paid in full before they honour the warranty. So lots of ways the queue can be skipped. There are, of course, personal guarantees that can be applied, and look, they're not captured by limited liability. So in that instance, what we might be looking at is a director having provided a personal guarantee, and that then might have an impact on the director's own personal solvency situation. As in the limited liability has not captured that liability. It has crept out of the company onto the director or other individual or other company themselves. So really on to I suppose examinership, which we would have we talk a lot about. I've done a number of examinerships myself, but the numbers have been quite low over the last, since 1990. We've had the legislation, so we're a good 30 years now. The idea here is to preserve the corporate entity, okay, because we've seen that on liquidation can be quite destructive for creditors, for employees, for the business. So we preserve the company, but we do some significant surgery to the balance sheet. Okay, so it's about injecting investment into the company post deal. It's about restructuring onerous contracts such as leases, so that the P&L going forward of the company is improved. And it's about doing a scheme of arrangement with creditors where they are written off what is owed to them, and they might receive a modest dividend to settle that amount. So in the case of landlords, it might be crystallizing a liability and pushing that liability through the scheme of arrangement, firing out a dividend to the landlord, but essentially the arrears of the lease, or it might be of a supplier, the arrears are dealt with then, and then going forward there might be some renegotiation of the contract or lease to improve the P&L. So it's not like a liquidation where it's essentially a sale of all the assets. It is purely a restructuring involving investment in the top half of the balance sheet, a write-off in the bottom half of the balance sheet, so improving the look of the balance sheet, and sorting out ongoing P&L matters like contracts and leases. Why would you do it? Well, legacy issues, COVID. There's a good reason that the market disappeared for a number of months. As a result, the rents might be too high. There might be supply agreements that can't be honoured. The balance sheet then broken, as we discussed. And essentially this is here to protect employment and to protect business ongoing. So it's meant to be value enhancing. So a bit of give from creditors and maybe a little bit more pro director and pro shareholder than liquidation is. What are the characteristics for success? Is that the business would have a reasonable prospect of survival, okay, an ability to attract sufficient investment to drive that restructuring. It requires an independent expert's report to set out that reasonable prospect of survival, and that the business trapped in a weak balance sheet has positive cash flow. So the business is viable even where the company is being pulled down by historic debts and maybe onerous contracts. So this independent experts report talks about the viability and appropriateness of examinership for the company, and the judge will look in detail at that report and assess whether it is good to grant examinership, effectively trammel over creditors' rights, to appoint an examiner to do the restructuring of the company. There are a number of things that need to be looked at. Court protection is granted from creditors, so there's a standstill situation. The business continues. Directors will continue to manage the business going forward. There's an extended time frame in COVID times of 150 days. Used to be 100 days, and that effectively allows now 5 months for the examinership to come up with the scheme of arrangement, to do deals with the various creditors, landlords, etc., and to get the deal done, get an investment done, and return a company that is in much better shape and can drive on into the future. And look, across the retail and hospitality sector, we've certainly been involved in a number of examinerships that have done exactly that. Disadvantages of it, of course, is the costs. You know, you have an independent expert, you have an examiner, you have the legals for petitioning, so that's barrister, solicitor, and then you have legals for the examiner, barrister, and solicitor. So effectively 6 sets of legals in and out of court, plenty of court scrutiny and reporting. There is a requirement for investment, absolutely, now. So there's quite high qualification requirements and that opinion from the independent expert. So that's really the reason why there hasn't been enormous numbers of examinerships over the last number of years. We sought to address this was through Examinership Light, which is for smaller companies with a smaller turnover. And I think that's seen a little bit of traction more recently. I think the issue there is the availability and the competence of judges in the circuit court to be able to deal with examinership as efficiently as High Court. So the legals would say there's not much in the difference, but certainly Examinership Light was a nod to that. And there is quite a structured timetable there. If the examiner or the judge along the way feels that it no longer merits examinership, it's just not going to work, then it's straight into liquidation, or a receiver. If there's a bank, a receiver might be appointed. I suppose one of the reasons why revenue haven't been too keen on examinerships in the past, they tend to take a neutral position, and banks in particular have been quite adverse to examinership, is because in a failed examinership, it adds a whole load more costs, of legal costs, examiners costs, etc., even on top of the liquidation costs. So your outcome as a bank or as a landlord or revenue, be it a secured creditor, preferential creditor, unsecured creditor, is then worse as a result of a failed examinership. So really the judge needs to be careful on who is granted examinership, because if they're not good candidates, they'll only go into liquidation and the outcome will be worse for all creditors. In 2014, with further legislation around schemes of arrangement, there is a scheme of arrangement in examinership. This is where the insolvent company does a deal with creditors and then goes into court and has the scheme of arrangement, the write down blessed by the court. The advantages are that the business doesn't have to be viable. You can just do the deal with creditors, bring it into court. You can get court protection if you want, but the deadlines are certainly looser. It's binding on creditors and the costs are less. So look, that all sounds great. The disadvantages of it are that the threshold for creditor support is quite high. It's 75% for each class of creditors, as opposed to only 50% for one class of creditors in examinership. Quite a low threshold in examinership, quite high in these schemes of arrangement. Does not impact secured creditors, and there's no ability to repudiate landlord leases, and there is that ability in examinership to repudiate landlord leases. So we haven't seen too much use of the Part 9 schemes of arrangement, although we were saying last April that we thought we would see more of them. That remains to be seen. Touch very briefly on receivership. Completely different angle here. Receivership is repo. It's repo by the bank. They're trying to get their value back, be it a hotel, be it a car, be it property. and essentially they're grabbing hold of the appointing receiver like myself. I've acted as receiver over hundreds of assets and companies, but they might appoint me to take control of that asset or business and then sell it on to their benefit. What's left over then goes to creditors after the bank has been paid or after revenue have been paid. So really out of the control of the director is a non-director approach, and once the receiver is involved, the receiver will do his own thing for the bank, and the directors really have lost the benefit of the business going forward. I did mention before that not all businesses obviously are incorporated. We still have many sole traders out there. And there's 4 arrangements now in personal insolvency that came in 2014, which will be of interest to sole traders who are unable to meet debts as they fall due and who are insolvent. The debt relief notice is for very small debts. It's really a tidy up situation. However, the debt settlement arrangement is up to a 5-year term for dealing with debts of sole traders, and effectively allows the sole trader to continue trading on and pays a monthly or quarterly amount to a PIP, a person insolvency practitioner. And then the person insolvency practitioner collects those monies, whatever is possible to receive in from the business going forward, and then applies those monies to the creditors. They get a percentage of what they're owed over a 5-year period. Interestingly, on the corporate side, the CVA, which is the Creditors Voluntary Arrangement, which is a UK style insolvency procedure, not dissimilar to this person insolvency procedure. I don't know why in Ireland we don't have a CVA, a corporate or creditors voluntary arrangement, where the business can continue trading on and repay an amount of the debt over a number of years, with the rest written off at the end. We seem to go for examinership, where it's a one-off solution, a bullet payment. But the debt settlement arrangement for personal insolvency allows a term where the business can pay off an amount of the debt over a period of time. Not dissimilar to the personal insolvency arrangement, this also involves secured debt. Okay, a slightly longer term, but in essence the same. Term can be five or 6 years. So you have a period of time to repay an amount of debt, what's possible, not all the debt, but an amount of debt, so perhaps a 20-30% dividend over the 5 or 6 years. Obviously, also a bullet payment can be done if a rich ante is uncovered and suddenly some third-party money is introduced. A bullet payment can also be done to creditors in both the DSA and the PIA arrangement. Bankruptcy, more popular in the UK for businesses. Still here, you have a situation where you're effectively sterilized from being active as a business person for a period of time. So still not an option for business people, although the term is much reduced from where it was at before. I'm just conscious of time here, and we have a few more minutes now where I wanted to touch on SCARP, the new rescue process, which was the draft bill was published last month. Before we go onto some questions, and I've cut and pasted from the press release onto this page. I suppose the main provisions of the bill in terms of what the minister is trying to achieve here. So I think in general this is mirrored on the examinership process. Okay, it's probably a nod to say that Examinership Light hasn't worked in terms of the numbers. The numbers are very small. Examinership Light was specifically for smaller micro companies also. But really it's the costs side and the court involvement which is driving up the costs, and the rescue process here seeks to avoid these costs. So it tries to have a rescue plan overseen by a process advisor who would be an insolvency practitioner like myself, but to try to run through the process without court involvement. Now, there is absolutely an ability for creditors to object, and then it does go to court. protection of the company can be got in court, and the court can effectively cram down creditors. But at first glance, it tries to avoid courts and tries to have a framework, a consensual framework for writing down debts. Just to go into it in a bit more detail, the steps look to be that, again, a statement of affairs would be required to set on both on a statutory and management information basis. Statement of affairs is very useful for company directors to see where the business sits on a winding up basis. A process advisor, insolvency practitioner like ourselves, would be appointed to report on the survival prospects of the company. So that's a bit similar to the independent experts report in examinership. The directors then pass a resolution appointing the process advisor and cease payments to creditors if they haven't ceased already. Now, really, at that stage, you'd want to have your plan together and perhaps an investment waiting in the wings at that stage, because the period of time to do the rescue process is quite short. The process advisor is going to consult with creditors, prepare the plan, but only has 42 days. Okay, so a month and a half to pull together a meeting of creditors to present the rescue plan, with a further 7 days for voting, so up to 49 days. Now that's a far cry from the 150 days in examinership. Okay, so quite a short period of time. So really the ducks would want to be lined up in a row prior to the process advisor being appointed. The voting is similar. It's quite low, 60% in number, and a majority in value of one class of creditors needed. So a little bit more than examinership, but not dissimilar. And certainly we think does not present a problem. In terms of creditors' rights, if they feel they're unfairly prejudiced, then they can object within 21 days. I think 21 days is probably quite a long time, maybe should be shorter, but certainly the creditor has the ability to apply to court to object. At that point, then the process advisor is applying to court for confirmation of the scheme, and it's about the court then trampling over the rights of the creditor and forcing the settlement to happen. In terms of eligibility, it's a micro scheme. So again, 12 million euro turnover, balance sheet up to 6 million, up to 50 employees. So two of those three criteria. Insolvent or likely to become insolvent. Okay, we talked about that earlier. And of course, that reasonable prospect of survival. This is not for unviable businesses. So we want to have a P&L or an ability to trade a business out of a company that's in difficulty because of creditors and onerous contracts that it has. The cost should be significantly less than examinership, because you don't need 6 sets of legals on this. The court involvement is not required. So, you know, for the kind of examinerships that are in and out of court that are fairly straightforward, you know, one would have thought the rescue process would be perfect for this. Keeps the costs very low. Of course, the costs then do start to accelerate if court involvement is required, if there's a creditor objection, or if the court has to confirm the scheme and give a hearing to that. Like examinership, there is that ability to repudiate landlord leases. I'll talk to that in a moment. And there's the ability to apply to the court for a stay on creditor action. So if one creditor is trying to prefer themselves by getting judgment and enforcing that stock, whatever it might be, ability to apply to the court to get court protection and put a stay on creditor proceedings. Okay, but again, the theme here is the creditor has to be better off than in a liquidation situation. So, you know, a bit hard for a creditor to object that they're unfairly prejudiced if the theme of the best interest of the creditor is put. And that's really to do with, is there going to be fresh money and new money investment coming in? Is there going to be a business that can drive on in the future? Are we preserving value here? That's the best interests of the creditor. Just to compare to examinership, then it's small companies only. It's by director resolution. There's no court petition. Okay, so the costs come right down. On state creditors, then they are excludable. So not dissimilar to the personal insolvency arrangements that we looked at. They have the potential to opt out of the scheme. Okay, So we know that revenue is granted preferential status. We know that they're given much more powers than ordinary creditors and much more protected. And they can, revenue as an excludable creditor, along with rates, can opt out of being crammed down if there is a history of non-compliance, some kind of ongoing tax audit or intervention, or there's under appeal. So, we'd say absolutely going for the rescue process, ensure that, the house is in order in terms of revenue, and not give them any excuse to opt out. And they have 14 days to opt out. If they don't opt out within 14 days, then they can be crammed down in the rescue process. As I said before, there's no automatic stay on creditor proceedings. In examinership, there is. You have to apply for it under the rescue process. You might not need it. It's much shorter period of time. Similar kind of voting. Because it's a shorter period of time, we say potentially there's much greater control of the business by directors. So really, you might have the deal effectively done pre the rescue process. Whereas in examinership, there's kind of 5 months there. Anybody can turn up to the examiner and offer to buy the business. And there is, at that point, it might move out of the control of the director, because there might be a third party investor who's willing to pay more than the director's own introduction of investment into the company. In terms of repudiation, then, what I say about repudiation is it is an option. It is possible to repudiate leases in examinership and in the rescue process. It involves a court application where there's no consent. If there is consent, well, leases can be surrendered. But if there is no consent, there is a repudiation process that involves calculating a claim. Meaningful engagement is a prerequisite now in front of judges. They want to see that an attempt has been made to engage with landlords and try to agree a deal before trying to ram home a repudiation and get out of leases, which is what repudiation is. Really, what I'd say, though, in both the rescue process and examinership, or even in informal negotiations, is the threat of using these processes for repudiation that will encourage deals. Okay, so maybe vary the terms of the leases, or maybe it might be that we're granted a surrender of a lease on one property, but we continue them on all others. But it's the threat of repudiation that is encouraging deal making. Just on PGs again, that there is a quirk of both rescue process and examinership, is that when it comes to voting for the arrangement, the guarantor, who might be a director, who has covering the personal guarantee, must be provided that creditor's vote. Okay, if that does not happen, then the PG may become defunct. It may be prejudiced in terms of the ability to enforce that PG going forward. Okay, so while the banks with their PGs and the bigger landlords are all over this, it's a tight window to pass the proxy and the report on to the guarantor, but maybe some of the smaller landlords and don't quite appreciate this. So some examiners will say that examinership is a way to effectively cram down personal guarantees, but it's a technical point if the holder of the personal guarantee doesn't appreciate that they need to pass on the creditor's vote to the guarantor. So look, there's a whistle stop tour. What I've tried to do is set out the toolbox in terms of what's open to companies, businesses, in terms of more formal restructuring. It's not just about liquidation. There's lots of ways that a business can continue on using a formal arrangement. But of course, it's important to do the informal attempt first of all, and for everybody to be aware of, both from a creditor and a director shareholder perspective, what the fallback is, what are the options for a business, because there is a suite of really good law there to help businesses restructure. And if they're at the bottom of the curve, the V curve, now might be the time to do the restructuring, so that future profits then are for the business, and maybe not to drag down the business in trying to deal with legacy creditors. maybe writing off a legacy position, moving on from a legacy position, so there's a bright future for trading ahead. So Keelan, that is my slides there.
Great.
I don't see any questions jumping up, but I'm conscious what I've gone through there is there's a lot of aggressive stuff in there.
Yeah.
Hopefully everybody was kind of has a bit of an understanding of some of that. I try to maybe do a whistle stop, put it together a bit in terms of where we're at.
Yeah.
It's important to know though, isn't it?
Yeah, absolutely, Angus. Yeah, no, it's good. It's good just to get a basic understanding of each scenario. And, if any member wants to have a chat with you, I'm sure there's no problem. We'll share your details, Angus, and they can run through different scenarios with you. Maybe just one there we might just briefly discuss is, I suppose a lot of members will be, have numerous stores, maybe a couple of different shopping centres, and they may all be tied into one company structure. And I suppose, they might have one problematic location that, is still proving a bit difficult. Is there any, advice you'd give, Angus, in terms of how to handle that scenario?
Yeah, I mean, it's an awkward one. It's to the theme of of having all your eggs in one basket, so you might have good eggs and you might have rotten eggs all in the one basket. The problem is the rotten eggs then drag down the good eggs, so and it also might be that there's some kind of a corporate guarantee or some other guarantee linked to an individual with significant assets outside the company that is also, impacting a situation. We've seen that with some of the larger retailers where they've had cross corporate guarantees also. What we were quite active with a number of years ago, and it probably took a couple of years to do this, was to structure the affairs of a business in such a way that various outlets were in separate companies, and there was a reason for this. If you're having a conversation with a landlord, let's say, and the business is not performing, if it's just in that company, then it's segregated from the rest of the business, from the other performing ones. So you can present the accounts of that company. It just has the one non-performing unit in it. The balance sheet does not look good. Let's call it badco. And, much easier to have a conversation with the landlord there in that instance. If the good businesses are lumped in, then much harder to have that conversation and to address that. So what we really saw is, I suppose, some companies diversifying out and moving leases into different companies. Now, it was harder to do that in the thick of the last recession, because I suppose essentially what you were doing was you were getting consent from landlords to move good businesses out into other companies, and progressively then your balance sheet was deteriorating down, and then to a conversation where the landlord is suddenly, Jesus, what happened? All the good stuff has been whipped out. That's very aggressive stuff, and a landlord may well turn around and say, hang on a second, now there's misfeasance of assets here. Now they've been leaking out the back door, and that's super aggressive. So it's not something that can be done overnight, but it's more a structuring thing going forward, and good risk management. So absolutely.
Okay.
The other way, I mean, we've certainly plenty retailers where we've had multiple leases in the one company, and we've done examinership, and we have had to just deal with that and bring in the value part of the business into the deal that's done with creditors, and it's it's probably not as good a deal that there would have been done if everything was separate, but so be it, and they've been successful restructurings also.
Okay, right. That's interesting to hear, Angus. Just the other question I had for you that kind of comes up a lot is in terms of urgency, Angus, with dealing with I suppose their landlords, that some are possibly holding off until things get much better and then come looking for their full pound of flesh.
Yeah, I suppose this is to the point of the curve, isn't it? And at what point do you do a deal? So I suppose if you're at the bottom of the curve and you're facing maybe a bright future, if you can get a deal done, I suppose that's the time to do the deal, isn't it? You know, before things take off, because otherwise you're in a situation where any future profits are being used to nurse legacy liabilities. So I suppose the ideal is to get the deal done now. But you know, in many cases, creditors are happy to to sit back and wait for that day. And you know, on the one hand, you might say that's great. They're not being aggressive. They're not demanding the pound of flesh. They'll sit back and they'll wait. But on the other hand, for the director, they're saying, well, I'm going to be paying off these guys for years to come. It's like a chain around my neck, and I'd rather deal with the situation now. And look, I have an example, one I'm involved with at the moment, where the landlord quite happy to set back, even gave a very generous write-off of rent. But it was one particular creditor who wanted to get paid immediately, forced the restructuring, and definitely would have been better off holding on. So that's from the creditor perspective. But from the director perspective, what they might consider is saying, let's do the deal now. If we don't do the deal, I'm not going to continue on. You know, I might look to liquidate. Or there might be some other arrangement that I would enter into. So, you know, there has to be a fairly upfront conversation and looking into the whites of the eyes as to, you know, who's, you know, is this real or is this not? And, you know, like certainly the last 10 years, there were some businesses that didn't do restructurings and that continue for the next 5-6 years with very significant debts that they were servicing. So what do they have for their 5-6 years after that? You know, a lot of pain, a lot of stress. You know, why did they not just do the deal at the outset when they could have? And I think there's a number of themes in Keelan. I think there's some of them.
Yeah. Yeah. Okay, Angus. No, that's super. Thanks for that update. And in fairness, your wealth of knowledge. So we'll share those slides, Angus, with everyone afterwards. And if anyone else has any questions, feel free send them in, and we can share them with Angus, and we'll also share Angus's details. So we'll leave it there. So
that's
thanks,
great.
Angus.
Many thanks. Thanks for
All
having
right.
me.
See you guys.
Cheers.
Bye.